Happy holidays to all of you out there. Hopefully you are enjoying your time off, perhaps with some family, maybe watching some football. But right over here at Brother Counsel Studios, we are still hard at work. So we've got some business to get to, and that is specifically the notice of removal that was filed by the defendants in Karen Reed's civil case. So let's remember what's going on here so that we can understand how this all works out. So remember that Karen Reed is being sued, and she is a defendant in the wrongful death case that the O'Keefe family brought against her, along with some other charges, some other claims like NIED and IIED. We've spoken about that complaint. Now, in that case, there was a motion that was not filed yet, but it was served on the defense about consolidating this new complaint. So let's remember, we are in two different courts. The court where Karen Reed is being sued in for wrongful death, and then there's this other court where they filed a complaint, and then they served the motion to consolidate both actions all into one beautiful case. That was the idea. Well, now we have this notice of removal that was filed in that other court. So how is this all going to work out together? That's exactly what we're going to get into. We're going to talk about the notice of removal. And before we do, though, I do want to make one quick announcement, and that is, first of all, thank you for all of you who have already donated to the special organization that I am going to be playing an ice hockey tournament to benefit, and it's called RCCS. The link is in the description if you want to help out at all. It's a really, really great organization. It helps families that are stricken with cancer, and we need to reach our goal. So if you want me to shut up about it, just donate, and then we'll be done with it. So we've got to reach our goal in order to play ice hockey in that tournament. Last year, we went to the finals. We didn't quite make it, but this year, hopefully, we are going to take it all home. Brother Counsel, you got it. So, of course, we're going to be providing you the updates with what happens in that tournament. Okay, so that is in terms of the charity. But now let's get on to business. So we've got these two separate cases, right? We got the case where the Karen Reed is defending against, and then we have this other case that they filed a separate complaint in, alleging all these civil rights violations against the McCabe's, the Alberts, former Trooper Proctor, should I say, and the Buchanan, etc. So what happens? Well, the first thing that we have to understand is that once you remove to federal court, the federal court then has jurisdiction over that complaint, over that filing. And therefore, even if you then move to consolidate it in a separate case, well, you're moving in state court to consolidate. The state court does not have jurisdiction anymore over that complaint. So they cannot even order the consolidation anymore. You've got to first get the federal court to remand it back to state court, and then maybe you can move on or proceed with the consolidation. So what I foresee happening is that this issue is going to be moot in the case of Karen Reed's wrongful death, right? That was the case where they moved to consolidate. It hasn't even been filed yet. It was served. That's the way it works in Massachusetts. And right now the state court does not have jurisdiction anymore over that matter. So as far as I see, this is going to proceed the state court where Karen Reed is defending herself for the wrongful death. And then there's going to be the separate claim that Karen Reed is the plaintiff in, and which there may be some counterclaims against her for defamation, which that's what it seems like from their answer. We'll see if that all happens. But that's how I see this proceeding. The Karen Reed proceeding in state court defending herself, which is what we can all see. And the other case where she filed the civil rights complaint, that's going to proceed most likely in federal court, unless for some reason they come up with some reason why they should be remanded back to state court. So we'll see if that gets litigated in the federal courts. But again, the federal courts are a lot more under lock and key. It's hard for us to see everything that's going on in the federal court. And which is why I always believed that the civil case, the defendants are going to want to remove to federal court so they can get out of the public sphere, and it's a little bit more under lock and key. It's not as transparent. We can't see everything that's going on in court. They don't allow cameras in there, et cetera, et cetera. We've been through that already before. So let's pull up the notice of removal and some very feisty language in here. So let's get started. Here we go. This was the notice of filing the removal. Let me just pull it up on my side also over here. All right. So please take notice that Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. So that's not all the defendants. If you take a look, let's see, there's many more defendants here. Michael Proctor, Sergeant Yuri Buchanan, Lieutenant Brian Tully. So what about those people? So we're going to have to see if the complaint addresses that. I'm sorry, if this notice of removal addresses that. Because, right, we know that there has to be unanimity when it comes to removing to federal court. So we'll see what happens. Every single party has to consent. So let's see if they address that in this notice of removal. So again, please take notice that Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins have on this date filed a notice of removal in the United States District Court for the District of Massachusetts, pursuant to 28 U.S.C. 1446. A copy of the notice of removal and all accompanying documents is attached hereto as Exhibit A. Moving right along. Let's go now. Exhibit A. Okay, that's Exhibit A. All right, now here is the filing, United States District Court for the District of Massachusetts, and this is just the federal version of what's going to happen. So notice of removal, here's again the same parties, and let's move on. Statement of the case is simply just stating what the plaintiff, Karen Reed, filed in this case, all the different counts, count 1, 2, 3, 4, 5, 6, and 7. By way of background, the Superior Court action arises from plaintiff's ongoing and malicious attempt to evade responsibility for the death of John O'Keefe by smearing and defaming witnesses. Very important word, defaming, because then they believe that they've been defamed and there may be a counterclaim against Karen Reed in the federal case for defamation, who participated in the prosecution of her. The case is vengeful. Abuse is a vengeful abuse of the judicial process, and removing defendants will make arguments in that regard at the appropriate time. Removal. Counsel for removing defendants accepted service of process on removing defendants' behalf, removing defendants' behalf on November 25th, 2025. And you can take a look at the Exhibit A if you want to see that acceptance of service. Therefore, removing defendants are timely filing this notice of removal within the 30-day time period from the date of service set forth in 28 U.S.C. 1446. So you only have a certain amount of time if you want to remove a case from state court to federal court. You don't have all day. You can't let the case be litigated in state court, and then after all the discovery and all the motions, you say, maybe we should remove this case to federal court. No, you have a very specific amount of time, and you only have 30 days. So that's what they're doing. They're filing it timely. That's their first point. All named defendants who have been served consent to and join in this removal. That's very important. All named defendants who have been served consent. Okay, so the named defendants who have been served, well, who hasn't been served? Well, all the ones that have been served consent and join in this removal. Defendant Brian Tully's acceptance of service was docketed in the Superior Court on November 24, 2025, and counsel for Defendant Tully has confirmed that he assents to this removal. So, okay, so Tully also agrees, all right? There has to be unanimity. While no acceptance of service has yet been filed with respect to Defendant Sergeant Buchanan's counsel has informed undersigned counsel that he consents to removal. So Buchanan also consents to the removal. Upon information and belief, Defendant Michael Proctor has not yet been served. He hasn't been served yet, according to them. But his counsel has advised undersigned counsel that Defendant Proctor consents to removal as well. So assuming that they actually make process and there is a service of process on Michael Proctor, so then the counsel, Proctor has a counsel apparently, and he's already told this counsel that they're also going to consent to the removal. So all parties are consenting to the removal. So the provision that you have to have unanimity, say that 3 times fast, has been satisfied. A civil action removed pursuant to Section 1441A requires the consent of all defendants who have been served. So there you go. See, they're saying it right out. They're saying we're not trying to hide this. We understand the law, and everybody consents here to removal, which is important. Okay, venue is proper, yada, yada. As required by 28 U.S.C. 1446, removing defendants will promptly serve written notice of the filing of this notice of removal and the removal of the state court action on counsel for plaintiff as evidenced by the attached certificate of service, and will promptly file the same with the clerk of the Superior Court. Okay, so we're going to serve the written notice of the filing of the notice of removal, and that's all going to be good. Pursuant to 28 U.S.C. 1446, etc., within 28 days of the filing of this notice of removal, removing defendants shall file certified copies of all records and proceedings in the Superior Court, as well as a certified copy of the docket and all docket entries. So we know the law. We're going to do it. Don't worry about it. The removal of this action terminates all potential proceedings in the Superior Court. Federal jurisdiction exists under 28 U.S.C. 1331. This is a civil action over which this court has original jurisdiction under 28 U.S.C. 1331. So if you want to get into federal court, you have to first show the federal court that they have jurisdiction. This is one of the first things that you learn in law school, in one of the classes, so that you got to have jurisdiction. The courts have to have jurisdiction over the claim. So when does federal court have jurisdiction over your claim? Well, there's 2 different ways to achieve that. One is diversity, which is not relevant in this case. And number 2 is, diversity is if you're from 2 different states. right? If the defendant is from one state, you're from a different state, and you file it in one state, so then the defendant who's from a different state can also remove it, and there's some other conditions as well, but that's not really relevant into this case. There's another way that you can get into federal court, and that is if there's a federal question. If the question, the cause of action surrounds a federal law, which in this case, that's exactly what Karen Read is suing under, a federal law, civil rights violation. Plaintiff's federal civil rights claim against removing defendants, namely count 3, which is conspiracy to deprive misread of our Fourth Amendment, is exclusively and expressly based upon the federal statute, and therefore raises substantial federal issues central to establishing plaintiff's claims for relief. In particular, plaintiff alleges in count 3 of the complaint that the removing defendants violated her federal civil rights by purportedly acting in concert to deprive her of her Fourth Amendment rights under the United States Constitution. We've spoken about that with Counsel Solomon. He explained this all to us. And if you didn't see that, definitely go check out that video, which we did breaking down the complaint that Karen Read filed, the civil rights violations. Where a complaint invokes 42 U.S.C. 1983, federal question jurisdiction exists. So there you go. Federal question jurisdiction exists under count 3, definitely, right? Okay. Continuing on, citing some case law here for that proposition as well. In addition, this court has jurisdiction over the remaining counts in the complaint by way of supplemental jurisdiction under 28 U.S.C. 1367, which provides in relevant part, in any civil action of which the district courts have original jurisdiction, the district courts shall have supplemental jurisdiction over all other claims that are so related to claims in the action within such original jurisdiction that they form part of the same case or controversy. And if you go to law school, you're going to hear that a lot. Case and controversy, or case or controversy. So this is basically laying out the following idea, the following suggestion. Let's say you have a case where you have some federal questions, you have some issues that surround a federal question, and then you also have some perhaps state claims that you may have as part of that complaint. Well, there's something called supplemental jurisdiction, which means that if the federal court has jurisdiction over some of the counts in the complaint, well, then they can also then spread their jurisdiction to include some of the state claims as well. And that's what they're arguing here. Indeed, the First Circuit has explained state and federal claims are part of the same case or controversy for the purposes of Section 1367 if they derive from a common nucleus of operative fact or are such that they would ordinarily be expected to be tried in one judicial proceeding. So, yes, you may have stated, meaning Karen Read may have stated some state claims as well, which she did. Again, if you go back and look at our analysis of the complaint, you'll see that there are some federal actions that she's complained, federal causes of action, as well as some state causes of action. But since they arise out of the same, a common nucleus of operative fact, it's all about the same facts, right? It's all based on the same idea. So then it would be ordinarily tried in the same judicial proceeding, and therefore there would be supplemental jurisdiction. Accordingly, this court may exercise supplemental jurisdiction over the remaining 4 state law and common law claims, counts 4 through 7 in the complaint. So they're laying everything out why there is jurisdiction is proper, which is what you have to do if you want to remove it to federal court. You have to say why you are allowed to remove it and why all the claims could be swallowed into the one federal action, which they are removing it to federal court. So that is what they're doing here. Conclusion, wherefore defendants Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins respectfully request that the state court action be removed to the United States District Court for the District of Massachusetts, and the court enter such an order as may be necessary to accomplish the requested removal. And that's it. And then they attach the complaint showing all the complaints, all the counts. And so exactly what he supposed to do if you want to remove it to federal court. And that's exactly what was done here. So that would also, again, include that there's some additional claims, which they said they may bring. Karen Read's side said they may bring these cases. Remember, there was a footnote that they have to first notify the county or the state before you actually sue them. That's a notice provision that they have to do, which they're doing right now. And then after that time elapses, so then they can actually add it as a complaint that's also going to be swallowed up into the federal case. So that is where we are right now. So again, what seems to me, what's going to happen now is that now federal court's going to have jurisdiction over this. And now the motion for consolidation, in my mind, is moot. Not mute, but moot. Okay, let's not forget that. All right, so that is the news with the Karen Read's civil case. And we still have yet to see the countersuit or the counterclaim of the defamation that the Alberts and the Caves and all those people are going to make against Karen Read in that federal case, most likely. So that is where we are right now. Hopefully this is all very clear right now. And again, we're going to be continuing to follow both cases now as much as we can. Again, federal court is a little bit more difficult, but that's why I assume they're going to go take it to federal court. I would think that the defendants do not want all the publicity that Karen Reed got in the criminal case, all the crowds and everything like that. Federal court, it's a lot more closed. And that's why I would assume, that's why I always assumed that they're going to want to remove this and they're going to want to handle this case in federal court. So the good news is, though, that we still get to see the state claim, the wrongful death that she is facing. We'll be able to see that, analyze it completely and fully to as much as we can. So that's going to be it for now. Again, hopefully you're enjoying your holidays. You're able to take a little bit of time off to watch this only like 16-minute video and get caught up on all the Karen Reed stuff. Now, also, next week, God willing, we are supposed to be starting the Brian Walsh case. And we do hope and intend on this channel to be covering and live streaming, number one, the trial, and hopefully also as well to bring you the recaps in case you're not able to catch the trial every single day. Hopefully we will be recapping every single day of that trial. So keep it right here, Brother Counsel, if you want to follow the Brian Walsh trial, which seems to be starting December 1st, this coming up Monday. And we will be all over that, like peanut butter and jelly on bread. I'm not sure if that works, but we'll try it. All right, well, that's going to be it for now. If you haven't yet at this point, please hit that subscribe button, hit the like button, and we will see you next time. Happy holidays, everybody, and we'll catch you at the next video.